Mr. Brocker, Ms. Jean, members of the Commission. Let me state, before I get going, what this case is not about. This case is not about whether these three students from Duke University were guilty or not guilty. Their Attorney General's office has done a thorough investigation about that. Mr. Nifong asked for the Attorney General's office to come in and independently review this. They made a determination. They've come to conclusions that these boys are innocent, and we take no issue with that, and that's not going to be a contest here. I would also state this case is not about whether Mr. Nifong took a weak case and tried to take it to jury. I'd say as a prosecutor, while he has a number of duties, one of those duties is to the people of Durham, and that's to pursue a case he believed a crime has occurred, whether it is a strong case or not. If we brought all prosecutors in here who had cases that were dismissed along the way or dismissed as a result of insufficiency of evidence before a judge, or if a jury cut them loose at some point, or the grand jury found there was no probable cause, we would be flooded with cases left and right. It is not unethical. It is not unethical to pursue what someone may believe to be an unwinnable case. That is not the issue here today. The issue here today is to make a determination as to when Mr. Nifong was handling this case, whether he committed any intentional violations or negligently committed any violations of the rules of professional conduct, and we would contend he did not. The reason I wanted to preface that we're not advocating at all to disagree at all with what the Attorney General's conclusions were about the three young students are, you still have to go back to March of 2006 and see what Mr. Nifong's mindset was at that point in terms of why he made the decisions he did. You must keep in mind, though while Mr. Nifong was a career assistant prosecutor for some 28 years prior to that, he had just become the DA, he just become the appointed DA by Governor Easley less than a year prior to this event occurring, and he had actually been out of the regular rotation for trying cases for a number of years due to health problems he had suffered in the late 1990s, and he had sort of been operating on the district court level, and he was just now getting to the Superior Court level again as a result of his appointment to Superior Court DA. So while he was vastly experienced in the court system, he was extremely inexperienced in terms of running the office and sort of being in an administrative position. One must keep that in mind. But we heard from Ms. Jean some of the information that Mr. Nifong learned about what Ms. Mangum may have been saying. Other information that Mr. Nifong learned early in the case was that Ms. Mangum did make these accusations about what had occurred in the house on West Buchanan, that she contacted the police. The police went back over to the house where she said she'd been attacked, and everybody was gone from that house. Not just the people who had attended the party, everyone was gone from that house, thereby raising the suspicions of law enforcement, wondering why people would vacate that house, including the people who lived there. We're talking about in the middle of the night, if nothing had occurred at that time. They interviewed some of the people who were on the street who'd seen what had transpired in the street, and the witnesses on the street told the investigators that they heard racial slurs made by some of the Duke lacrosse students toward these two girls that were leaving in the car. Much is made about Mr. Nifong interjecting race. I would contend Mr. Nifong's comment on race was based upon that and some other comments that were made later on during the course of the investigation. Ms. Mangum was then taken to a SANE nurse, which is a sexual abuse nurse examiner, someone who is qualified to examine people who are accused of, who are alleged to have had sexual abuse committed against them. Her name was Tara Levison. Though she graduated very high in her class, she was relatively new in this field in terms of actually being out there. She examined Ms. Mangum that night, and she determined that Ms. Mangum was acting consistently with someone who had been sexually abused that evening, that she appeared to be in pain, that the way she was reacting was consistent with someone who had been sexually assaulted, that she did not appear impaired, And as far as she would be allowed to testify, she will say, and you will hear from her, that she appeared as somebody who was sexually abused that night. So now we have law enforcement with someone saying they were attacked. We have them going back to the house, trying to find out what happened, where everyone is gone. We've got people saying there were racial slurs made toward the individuals, all consistent with what Ms. Mangum was saying. They went, within the next day or so, back to the house to execute a search warrant. In executing the search warrant, you'll hear Investigator Hyman testify, they knocked on the door several times, for 45 seconds to a minute. Nobody came to the door. When they let themselves in, and when they came in, they found the 3 individuals who were living there who did go down and make voluntary statements. But in their voluntary statements, they made statements, though they denied any sexual misconduct toward Ms. Mangum, they made some statements that corroborated what Ms. Mangum said. In addition to her being there to do topless dancing, she had mentioned to the investigators that she was threatened with a broom to be used untowardly toward her, and they were told by the people living in that house that she was threatened with a broom. She told them about racial comments that were made toward her, and they told her. They told the investigators about racial comments made toward her. So now you have an investigator looking at this. You have her statement. You've got the saying. You've got the comments corroborative about the broom and about racial comments from people in the house and about witnesses on the street. In addition, during this period of time, they find an email. They find an email from one of the lacrosse players talking about skinning the strippers. Skinning the strippers. Some may see that as some sort of innocent comment, not Mr. Nifong. So this is the information that's being brought to Mr. Nifong. And I would contend to you, Investigator Hyman will tell you, as he said under oath, I would contend what he said under oath in deposition, that when he talked to Mr. Nifong and they asked about Miss Mangum, he said she sounded like she was telling the truth. During this period of time as well, initially there were the 3 individuals who came forth and made the statements, and a number of other individuals were supposed to meet with Investigator Hyman and Sergeant Gottlieb. During that period of time, they got in touch with lawyers, and those lawyers advised them, probably as I would do, not to make any statements. There's nothing wrong with that. And there's certainly nothing that you could ever use in the courtroom. However, what we're talking about is the mindset of Mr. Nifong in terms of what is going on. He's looking at this case, and he's trying to make a determination about if these people initially came forward and now everyone is being quiet, why is that? And then he starts making the statements that he does. But when he starts making those statements that he's making, and I believe you will hear him testify that he regrets making those statements, but in those statements that he made, he was not making them with the intent to substantially prejudice the jury. At that point, there had been nobody charged. They were still looking for suspects. And he felt, as the duly elected, or as the DA of Durham County, he needed to solve this crime. He wanted to get out there to the public how serious this crime, that he believed a rape had occurred, that there are 3 people out there who, at least 3 people out there who were involved, and he wanted to solve this crime. And his statements were a way of getting out there saying, people need to come in and tell me, because we need to know, we need to put a bed to that. That being said, and again, some of the statements clearly were outlandish, we're talking about a very brief period of time. We're not talking about someone who talked from March until January 2007 when he got out of the case. I would contend 98% of the statements you're going to have before you were made between March 8th and April 4th. And then he stopped talking. He realized, again, I'll let him testify, but I believe he realized, A, it would be improper to go on, and secondly, too, at this point they were starting to narrow down who the people were, and he was not going to make comments once an individual was charged. And I contend almost all statements are made prior to anybody being charged, and they're not being made in reference to any one individual at the time they're being made. We've heard you've heard some comment in opening statement about the photo array that was shown to Ms. Mangum and whether it was suggestive or not, or the improper nature of it. Rather than hear our conclusions or our arguments about the suggestiveness or lack thereof of the photo array, you'll have the opportunity to see that. Mr. Nifong, because this was a relatively new procedure, and he will liken it to the yearbook identification when he knows somebody was wearing a certain high school sweatshirt, and he'll show a yearbook to the individual who's making the accusations from people who were at that high school to see if they can help identify. He knew this was a new photo array, was not positive as to how